to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, Your Honor.
Okay. And Mr. Trush, I know that we have a challenge. Before we get to that, are there any factual corrections, additions, deletions?
No, Your Honor, not from the defense.
Okay. And then the challenge to the scoring is to OB1. I did have a chance to review your argument on that. Was there anything that you wanted to present by way of oral argument here today on the record?
Just to kind of briefly go over the sort of high points of it, I think it's pretty straightforward. As the court knows, there has to be a preponderance of the evidence to support any scoring of any particular variable and at any particular level. In this case, I don't see how the court can come to the conclusion that the firearm was discharged at somebody or aimed at somebody based on the information in the PSI. And we actually attached a copy of one of the pages from the police report, which supports it even more, because in that page, in paragraph 2, sentence 2, the alleged victim states they were unsure if the subject aimed the weapon at them. So I don't think that we can support that it was discharged or aimed at him by a preponderance standard. I think that there is support that a weapon was displayed, which will only be scoring at 5 points as opposed to 25.
Thank you, Mr. Rowland.
Well, Judge, and again, I understand the defendant's position. However, we also have the indication in the police report and by the victim that he felt that the gun was not only pointed at him, but shot in his vehicle's direction. And while it's true that we didn't recover the slugs, or law enforcement didn't recover the slugs, but had they hit the defendant or the victim or his vehicle, we'd be dealing with much more serious charges here. I think the court can quite frankly score it either way.
Okay, thank you. Again, I did have a chance to review the PSI. I did review the statement that was provided by the defendant from the police report itself. And looking at this under a preponderance standard, I think, in terms of direct evidence, I think we do have some issues. We don't have any, kind of qualified statement by the victim that he saw it aimed at him or that the round was discharged in his direction. But the court doesn't have to just look for direct evidence. The court can also rely on circumstantial evidence. And in this case, what we have is generally a road rage incident. I think there's plenty of evidence based on the victim's statements that Mr. McLeod, was upset, angry during this encounter. There's sufficient evidence to support, I think, a finding under preponderance standard that the weapon was fired. The victim described hearing 2 gunshots. The victim also indicated that they were familiar with firearms and were, was able to accurately identify that firearm as a semi-automatic pistol from his vantage point. And then we have evidence that corroborates that the gun was fired. We have a 7-round clip, and in the police report it indicates that there was 1 round in the chamber and 2 rounds missing for a total of 5 rounds, which would also support the victim's statement. So when you combine all of those things together, and in particular, again, that this was part of a road rage incident, I think circumstantially the court has sufficient evidence to find that those rounds were fired in the direction of the victim's vehicle in this case. So I think based on that, it does support a scoring of 25 points for being discharged at or toward a person. So the court will deny the challenge on those grounds. Were there any other variables?
That was the only variable to be challenged.
Okay. Mr. Rowland, do the people have any additions, deletions, or corrections?
Judge, for the record, this is just apparently, it's already been corrected according to probation parole, but under defendant's history, 24 or 25, it shows that his case of possession of methamphetamine in the nominal county is still pending. Obviously, he's already been pled and sentenced on that. I don't know if the court got an amended PSI that had that corrected or not, but we would ask that to be corrected for the purposes of the defendant's PSI. He's already been sentenced. In fact, as I understand it, according to Mr. Leo, he's actually going to be looking at MDOC time.
Okay, Mr. Church, any objection to that update report?
No, I would just ask, Mr. McLeod, what did you get sentenced to there?
18 months.
I have no objection to that.
Okay. All right, Mr. Rolla, any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocution?
Just briefly, Judge. This is an 8th felony. It's, as the court's already indicated, it was a road rage incident with a weapon. The victim did not provide a written victim impact statement, but notified our office that he in fact would not be appearing here today at sentencing, specifically out of fear of additional retaliation and making both himself and his family members targets for that retaliation. So I wanted the court to know it's not a situation that didn't appear here and didn't give a statement because he doesn't care about it. Quite to the contrary, he feels more important about the safety of his family than he cares about specifically being able to appear here before the court. And I guess in a road rage incident where someone was shot at, I think that probably speaks more volumes than anything else I can say to the court. As to the defendant's claim that he was only taking pictures of his gun while driving on M32, as noted by Deputy Jones, the timestamps shown in the photos were taken hours prior to the defendant's felonies being committed. So I think that also says more, and perhaps maybe more concern, confirms the concern that the victim in this case may have. For those reasons, Your Honor, we do believe that incarceration is appropriate. I understand he's already looking at 18 months to MDOC, which is why I brought that up previously. Thank you.
Mr. Church.
Thank you, Your Honor. As the court's well aware, this was a road rage situation. In response to Mr. Rolla's statements about, whether or not he was taking photos of the gun or those statements made to the police, at this point, we're past that. Mr. McLeod has acknowledged what he did. He openly accepts that it was a road rage incident. He accepts that he displayed the gun and discharged it. He disputes it was discharged towards the person, but again, we're past that at this point. He stood before the court and acknowledged those things. I think sort of responsive to the prosecutor's statements about the victim, obviously, everybody knows the score here, which is to say Mr. McLeod is incarcerated right now in Crawford County. Everybody knows that the sentence here, because of the felony firearm, is necessarily an MDOC sentence. I certainly can understand how this type of situation can be scary because there isn't a connection, right? Mr. McLeod doesn't know who this person is. This person doesn't know who Mr. McLeod is. I talked to Mr. McLeod quite a bit about this. I think he is ashamed of his behavior here and embarrassed. I think he is upset with himself because he's put himself in a position to be taken away from his family, and he has 2 young kids. I can't explain the circumstances here. I can't explain what leads someone to do that. I think the court can probably recognize that a disturbing number of the cases that we get are road rage situations where people act far outside of sort of the normal behavior they would. And I don't have a good explanation for why that is, but we do see perfectly irrational people behave very irrationally behind the wheel of a vehicle. I would suggest to the court, given the circumstances, considering that there is already a prison sentence that's been imposed, considering that Mr. McLeod has the mandatory 2 years consecutive to whatever the court sentences on the underlying offense, and taking into account some of the specific circumstances here, which just kind of structurally, because of the other charge, it appears to me that there's about 2 to 4 months, depending on sort of how you calculate it, that Mr. McLeod has been incarcerated that he's not getting any credit for, in addition to the consecutive nature of the sentence here, that the court can achieve all of the goals necessary while still being at the lower end of the guidelines here. And that would still be a significant MDOC sentence with significant punishment for what happened here. Thank you.
All right, thank you. Mr. McLeod, was there anything that you wanted to say today?
Yes, Your Honor. First, I'd like to say there are a lot of people I know an apology to for my actions this past year, but the kids deserve one of the most. Junior, who is turning 6 this summer, my daughter Eleanor, who is 7. My kids love me more than anything, are so innocent when it comes to the effects dad's actions cause. And also to Mr. Savage, because no matter what altercation we had, I'm in control of my own actions and didn't need to or have the right to take it to another level. Not only should I have not been carrying a gun to begin with, I shouldn't have given the impression that I would use it as a scare tactic or in any other way. I'm sorry for that as well. I'm going to use this time to practice making better decisions and to control how I react to situations and get back on the right path. And when I get back home to my kids, practice every day being a good dad and never leaving them again. That's all I have, Your Honor.
All right, thank you. I did have a chance to review the pre-sentence report. Of course, I'm familiar with the facts that regarding the situation here. And I think certainly, Mr. McLeod, you're right when you say you are in control of your own actions. This was clearly a circumstance that you kind of created your own problem here. You could have easily just driven away from that situation, calmed yourself down and moved on with your life. And this, you wouldn't be here on this charge here today. And Mr. Savage wouldn't have had to, go through the trauma, especially psychological trauma of having an incident like this occur in the middle of what was probably otherwise an ordinary day for that person. Given your past history that results in higher guidelines in this case due to your past record, and the court does have some concerns for public safety, given that there's indications in the report that you were using alcohol, potentially some controlled substances. There was MDMA found, and then being in possession of a firearm, which you were fully aware that you shouldn't have been in possession of, and then actually, attempting to use that firearm as part of this incident. So things that just got compounded. Statutorily, there are additional penalties for this, as you're aware, and I think that's because these types of crimes are serious crimes, and the court and our community has an interest in discouraging and deterring people from engaging in this kind of conduct. All of that being said, there weren't any actual physical injuries, thankfully, in this case, and so I think that warrants some consideration here in terms of an appropriate sentence. All of that being said, your guidelines are 19 to 47. The court finds that a sentence as to the possession of a firearm by a felon charge as a habitual second, that's count 3. An appropriate sentence for that charge is 24 months to 7 years, 6 months. You do have credit for 166 days served. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to the felony firearm charge, 2 years with credit for 166 days served, and that sentence to be served consecutive to the possession charge. You do have the ability to appeal each of these sentences. If you haven't already received it, you will be provided with written notice of your appellate rights, as well as how to request a court-appointed lawyer to help you with any appeal. Mr. Rolla, anything further that we need to address on behalf of the people?
No, Your Honor, thank you.
Mr. Trush?
Nothing further.
Are we going to have those?
Your Honor, I was just going to take it over to the Crawford County Jail. I'll be over there this afternoon.
Okay, so Mr. McLeod, Mr. Trush is going to bring you and hand deliver your appellate rights to you today. And that's all for this hearing today. The court's going to disconnect at this time. Versus Heather McHugh. Is Ms. McHugh present?
Yes, sure.
The record showing my phone deaf people.
Thank you, Your Honor. Richard Trush on behalf of Ms. McHugh.
The date and time set for sentencing in this case Ms. McHugh, have you had an opportunity to go through the pre-sentence report with Mr. Trush and talk to him about that?
Yeah,
Okay. Mr. Trush, again, I know we do have a challenge to the scoring, but are there any other corrections, additions, or deletions to the report?
Yes, Your Honor, I do have a couple. So starting on CFG 284, page 10, under the section listed under the marriage section, the marriage narrative. Second paragraph says defendant began dating Dylan Robbins in 2019. They actually got together in 2016.
Mr. Roll, any objections to that correction?
No, Your Honor, thank you.
And then next page, so CFG 284, page 11, under substance use and treatment. Methamphetamine list start of 2021, end date of 2022, says frequency weekly. Her indication is that she's only used methamphetamine about 3 to 4 times in her life.
Mr. Roll, any objection to that change?
Judge, if the court wants to put in there that the defendant indicates 3 to 4 times, we have no objection.
Okay. Any other corrections?
Other than the guidelines challenge, no.
Okay, and then the challenge to the guidelines is the OB 19. I did have a chance to review your written brief, Mr. Trush, and then your response, Mr. Rolla, as well. Any oral argument today, Mr. Trush?
Hey, Your Honor, I guess I would start with, insofar as scoring it at 15 points, I think, in my opinion, that's pretty clear. Both of those levels of scoring, I think, require the use of force or a threat to either interfere with the administration of justice or emergency services. I think in the situation here, the court may find that there was interference with the administration of justice, but I don't think the court has anything to find that there was a threat of force or use of force to accomplish such a thing. As the prosecutor pointed out, the court may rely on concealment after the fact. I'm going to address that in a minute, but again, I don't think there's anything that supports any sort of threat or use of force. In regards to concealment, I guess what I would indicate to the court is I think that if there's something like that, it has to actually, it's not just that the condition has to exist, it has to actually interfere with the administration of justice. In the situation here, quite frankly, I don't think there's any interference with the administration of justice, which is to say, in order to interfere with the administration of justice, there has to be something that slows, hampers, hinders an investigation. Quite frankly, the facts here, Ms. McHugh sped the investigation up pretty significantly. Because when the police wanted to search her car, she didn't require them to get a warrant. She didn't require them to do anything. She consented to that search of the car. So effectively, the concealment didn't slow down the investigation at all because of her subsequent actions consenting to the search of the vehicle. So that would be my response to the prosecutor's response.
Thanks, Mr. Rolla.
Judge, a couple of things, with all due respect to defense counsel, leaving somebody that they know have overdosed to die and not even calling 911 would seem to be pretty much a physical assault on that individual. That being said, however, as to the concealment argument, the defense argument I submit has absolutely no merit for the following reasons. First and foremost, while the defense says, well, she consented to the search of her vehicle. Well, that's true. However, look at the circumstances under which that consent occurred. First off, the law enforcement isn't even called right away. Second, the defendant, in an attempt to conceal her crimes, takes the remainder of the fentanyl, puts it into a lottery ticket, folds it up into something else, hides it in their vehicle, and while the court's well aware, we've dealt with the situation that many times, defendants often will think that they can have their vehicle searched and the police won't find the drugs that they have so carefully hidden. That's what happened here. But as indicated in all the cases that are cited by the people, as specifically found in People versus Sowers, defendants acts of a defendant that constitute an attempt to avoid being caught or held accountable in the sense of offense specifically scores 10 points under OB-19. There is no way to say that that didn't happen. Now to say, well, the investigation was shortened because while she consented and they found it, I would respectfully submit to the court, especially since the burden of proof is only preponderance for the scoring, that the defendant took steps specifically to try and prevent the evidence of her crime from being discovered by law enforcement, both by either delaying in the reporting of the overdose and/or also in trying to hide the remainder of it.
I did have an opportunity to review the law pertaining to OB-19 under these circumstances. I agree with Mr. Trush to the extent that I don't think 15 points is an appropriate scoring, given that there was no use of force or threatened use of force in this case. However, I do think scoring is appropriate at 10 points. I think clearly there wasn't an attempt to interfere with the administration of justice here, an attempt to hide what was going on in order to avoid responsibility on behalf of Ms. McHugh. Under these circumstances, it's not an unusual occurrence, unfortunately. Lots of circumstances where people, out of their own self-interest, will attempt to hide what's going on to the danger of the person who is overdosing, unfortunately. In this case, luckily, Mr. Robbins did not die, although that's certainly a possibility. But the court finds that under a preponderance standard, there's more than adequate evidence to support finding that Ms. McHugh at least attempted. The court doesn't have to find under OB-19 that there was actually some type of slowing down of the investigation. It's the interference or attempted interference with the administration of justice. So the court finds that OB-19 would be properly scored at 10 points, which reduces the OB score to 16, but does not change the OB level. The guidelines remain 10 to 23. Would you agree with that in terms of the scoring, Mr. Trush?
Yeah, sure.
Mr. Rolla?
Yes, Your Honor.
Oh, Mr. Trush, were there any other objections to the scoring?
No, Your Honor.
Mr. Rolla, did the people have any additions, deletions, or corrections?
No, Judge.
Did the people have any challenges to the scoring?
No, Judge.
Anything on behalf of the people for allocution today?
Well, Judge, in this particular case, this is the defendant's not only her fifth felony, but it's also the controlled substance offense of being minor offense. The defendant, in this case, not only overdosed the victim with fentanyl, but then chose to try and cover her for crime by hiding the remainder of the fentanyl. And she, instead of immediately calling 911, or as the defendant put it, quote, she did not reveal that Mr. Robbins was overdosing in this quote, but was prepared to tell police and EMT personnel if they didn't find it out on their own. That's the only way she was going to come forward with that. In light of the circumstances in this particular case, the guidelines in this case are 26 to 40. The court should consider, quite frankly, in the people's opinion, a sentence at the higher end of the guidelines. Thank you.
All right, I just want to make sure that we're on the same page. I've got guidelines at 10 to 23.
So I would agree the guidelines are 10 to 23. I would remind the court this plea was done with the second or subsequent offense enhancement,
Which
meaning
means
the
that,
court has the discretion to double it, right?
which is the guidelines I was referring to. Judge.
Okay, understood. Oh, thank you.
Thank you, Your Honor. There is a lot to unpack with this scenario. So I think we probably can't get to where we are without starting with where we've been. This is a circumstance where Ms. McHugh was in a relationship with Mr. Robbins for several years. Ms. McHugh and Mr. Robbins have both struggled with substance abuse in their lives. This is a relationship that was bad for both of them. But how do we get there on that day? What happens on that day is that Mr. Robbins contacts Ms. McHugh, tells Ms. McHugh he has some drugs that he wants to use. He is unable to use the drugs himself because he cannot find a vein. He calls Heather. Why? He calls Heather because he's been in a relationship with Heather for a long time, and he knows that he can manipulate Heather into helping him. This is a situation that is almost wholly unique. Because this isn't a situation when we talk about a delivery of drugs. Usually this falls into one of two categories, right? Usually we're looking at a situation of somebody who's selling drugs for profit or selling drugs to support their own habit. That's not what this is. Sometimes we see on the other end of things, what we would term social sharing. That's not what this is. This is a situation where Ms. McHugh did not have any drugs on her on that date. The drugs were Mr. Robbins. So how do we get to a delivery? Mr. Robbins asks Ms. McHugh to prepare a needle, prepare a syringe for him to use. She does. Mr. Robbins asks Ms. McHugh to help him find a vein, which she does. And then Mr. Robbins uses the drugs. I don't say that to the court to suggest to the court that that is appropriate behavior for Ms. McHugh. And we all know what the right response would be, which is no, you don't help somebody do that. But I think it's important to understand the relationship that they're in the context of this. So that's how we get here. But what's happened since that date? Since that date, Ms. McHugh has engaged in a lot of treatment to address her issues. So the first thing we start with, she's been engaged in Bear River. She's been engaged in Bear River since January of 2023 through present, prior to this incident even happening. And she's maintained her sobriety. She does counseling there. She has a recovery coach, and she can tell you how many meetings she does, but she's provided me the meeting lists, and she's doing a ton of counseling through Bear River. And again, maintaining her sobriety through all of this. As a result of this, there's a CPS case that's open. She's voluntarily engaged in services right now. She's engaged in services through the New Life Pregnancy Center and through the Families First program. She's completed over 70 parenting classes to date. And I want to emphasize, the court there still doesn't have jurisdiction. Everything she is doing is on a voluntary basis. In addition to the substance abuse counseling and the parenting classes, and as the court's probably aware, CPS is sort of like an umbrella providing numerous services, not just parenting related, but to get her to a position to be a stable parent. So it's addressing issues beyond just parenting. In addition to that, she's also working with a counselor from Work It Out, and that is for specifically sort of her mental health aspect of it. And again, that's a little different than the Bear River stuff, which is sort of all through the lens of substance abuse. Work It Out is kind of working on her issues in terms of things like codependence, healthy relationships, healthy boundaries, those types of issues. So that leads us to what should the court do in terms of the sentence here today. On one hand, we have a situation which is extremely dangerous. And the court, I'm sure, understands that in every sense of it. This is a situation where we see the real world danger that is often just a specter in our cases of people who can overdose or can have these things happen. What we see here is this in real life, this really happening. What we also have is a unique situation. We have Ms. McHugh's specific situation where she's done more to address her issues than the vast majority of people who appear before the court. We also have a situation where the court has discretion to double the guidelines and then a wide amount of discretion as to what a sentence should look like within those guidelines. We also have Ms. McHugh's prior history, which the prosecutor pointed out there is some history. I would point out to the court that her last felony conviction is almost 10 years ago in 2015. Since then, she's been limited to the present offense and 2 misdemeanor offenses. Now, and again, I would suggest that that shows progress, especially from where her prior history was. I would suggest to the court that doubling the guidelines is probably not appropriate in this situation. I would suggest to the court that the court has discretion to go with a county jail sentence or a sentence in MDOC. I would suggest to the court a county jail sentence is likely more appropriate here, given the substantial steps that she's taken since this, the unique situation that brings us here, and again, her relative lack of prior history in the last 10 years. Thank you.
All right, thank you. Ms. McHugh, anything that you wanted to say today?
Yeah, I also lost my son over this, and I am fighting since like 2 days after this happened to get him back voluntarily. They still don't have jurisdiction, and David Delaney is my probate lawyer, and he told me if I go to prison, they can order my rights to be terminated, and I'm going above and beyond, like, whatever, his dad's done nothing. And so, like, if I go to prison, it's almost guaranteed my son's gonna be put up for adoption, and my whole family's gonna lose him. I'm gonna lose him. And I'm like, I see him two times a week, and I had to tell him, Mom, you made a mistake, buddy, and I have to go away for a little while. And he goes, well, when you come back, then can I come with you? It just breaks my heart. And like me and Dylan have had like a very codependent relationship, because from the age of 15 to 25, I used like, never was more than like 3 to 9 months sobriety. And I moved up here in 2011, and the last 13, since May 2nd would have been 13 years. I've used like illegal substances like 10 times, and like that's, I don't know, I'm not like trying to justify it or anything, but that's like great compared to what I did, 10 years of use. And in addition to what Mr. Truth said, I also do an opiate use disorder, opiate home health program at Bear River that has its own treatment plan. I do 2 to 3 drug tests a week and haven't failed any. I took a drug test even 2 days after this OD, it's clean. It's just a very codependent relationship, and I've been working on it for 1.5 years to get better. And I don't know, I'm doing parenting. I completed a Wellsprings Lutheran Services, if you know what that is, Families First program, a fostering parenting program, visitation program, the opiate use disorder, opiate home health since February 2023. I see 2 individual counselors a week, one at Work It Out for mental health and one at Bear River for substance use disorder and other stuff as well, because they're counselors. But and I know I'm reading stuff, a bunch of parenting classes. I'm just like, I quit smoking cigarettes a few years ago. I was accused of being under the influence of my Suboxone, so I switched to Sublocade, so that would never happen again. Like, I'm trying to better myself all the way around. Like, I need my kid back. I need my kid. I understand what I did was wrong, and I did call 911, and it wasn't when somebody told me to. I was looking for a phone when she said call 911, and I did conceal the fact that it was an overdose. They did ask me if he uses drugs, and I said anything and anything in front of him, but I was like, I had to give him CPR. When EMS came in, I stood by the door, because if they didn't figure it out right away, I was prepared to tell them, because I OD'd 4 times, like when I was like 19, 20, and luckily I was with my daughter's father, who was a Detroit fireman, to give me CPR and bring me back to life. But I knew the guilt and shame that I felt, and I knew Dylan was gonna feel that. I felt that. I knew his mom was gonna blame me for everything because we don't get along, and it was just like a chaotic situation. His mom's a CNA, so and I kept like trying to sit him up, because he was like fell straight off his bed. And every time I get him sit up, he was gasping for air, but I couldn't get him all the way up because he's dead weight. So I ran and grabbed his mom first to help sit him up to get him, keep him breathing while I called 911. And we got him up together. She was rubbing his chest, and then I turned around and was looking for a phone, and she goes, call 911. I said, I'm looking for my phone. And she goes, go grab mine, it's out in the kitchen. And I said, wait, mine's right here, I'm calling. And then 911 kept telling me to step away from her because she couldn't hear. And even though she's trained in CPR, I think it was like too personal of an experience that she was panicked like me and didn't know what she was doing. So I had to put my phone on speakerphone, and she pumped his chest while I breathed into his mouth and stuff till EMS got there. And I know what I did was wrong. And like, I don't care if you give me 5, 10 years probation in addition to jail, I will not fail you. It's easy for me to stay clean as long as I stay away from Dylan. I've already been working on my codependency for 1.5 years, and that was the main problem. And I can't lose my son, believe me.
Okay, well, I read through the report, so I'm familiar with what happened in this case. And I'm familiar with your background and your circumstances as well, based on the information in that report. I think there are some mitigating circumstances here, as Mr. Trush pointed out. I don't have any reason to doubt that you've been trying to take steps to get yourself in a better position in terms of your ability to deal with your substance use problems. I did get a report from Community Corrections indicating that you haven't complied with your bond conditions. So those things are all things that warrant some consideration. I can also, accept that your relationship with Mr. Robbins was the nature of that relationship, had an effect on your decision making in terms of whether or not to provide that substance to him. And those are all things that, again, I think warrant consideration in terms of what the sentence should be. There are some bad things here though too. I mean, you could have easily died that day and you would be here facing a delivery causing death charge. And nobody knows what's in those substances. If you're a user yourself, you know that better than anybody, and you indicated you've overdosed in the past. So regardless of whatever pressure that you felt from him, you also understood potential implications of what you were doing, probably better than most people. And you still made the choice to provide that to him and potentially end his life that day. And all the reasons that you gave for doing that are fine reasons, but do any of those justify helping somebody potentially kill themselves? And I think the answer is no. And the court and the community has an interest in deterring that kind of conduct. Also looking at your history, some of it is older history, but you've been to jail a number of times, you've been on probation a number of times in the past. Given the nature of your conduct in this case, I think the court has to look at a more serious penalty following the principle of progressive discipline. And so in this case, I don't think a doubling of the guidelines is appropriate because the mitigating factors that I mentioned, the sentence within the guidelines, original scored guidelines is appropriate here. And the court finds that a sentence with Michigan Department of Corrections is appropriate given your past history, given your conduct. The court is going to sentence you to the Michigan Department of Corrections for a period of 18 months to 40 years. Court is going to order that you have 2 days of credit, crime victims assessment of $130, court costs of $325, $50, and $68 state costs. You do have the ability to seek an appeal of this sentence, and Mr. Church began this with you. Acknowledgements, please.
Yeah, that's Your Honor, I'm returning the executed advice of the public.
Thank you.
It's gonna go just in your personal property, so you probably want to leave this.
They'll get you set up with a red once they get you over there. And I'll let Mr. Delaney know what's happening. So if you want to take the paperwork with you, they'll put it in your property and it'll go with you. If you want me to give it to the person who's with you here, I can be happy to.
Here's the server, up.
I need to take just a brief recess, so maybe 5 minutes and then we'll be right back on the record. Okay? Thanks. We're back in the record. Before we get started, I know we've got a number of children present here in the courtroom today. This is not an appropriate place for small children to be, particularly during these types of hearings. So anybody who has minor children here with them, you need to vacate the courtroom at this time. If you really want your children to watch what happens in criminal court, we broadcast all our proceedings to YouTube. You're more than willing to do that on your own time, but it's not appropriate for here in the courtroom. That being said, we have next case, People versus Laporte. This is case number 236481. If I could have counsel for your appearances on it.
Thank you, Your Honor, for the record. I call back people.
Thank you, Your Honor. Richard Trush appearing on behalf of Mr. Laporte.
This is the date and time set for sentencing in this matter. We had to make some corrections to the PSI. The last hearing, I believe those were made. Mr. Trush, did you have a chance to review that? Changes that needed to be made?
I did.
Oh, Mr. Laporte, did you have an adequate opportunity to go through the pre-sentence report and talk to Mr. Trush about that? Yes, sir. Okay. Mr. Trush, are there any additions, deletions, or corrections?
So the issue that I would raise to the court.
Deputy, can you close the door there, please? It doesn't do any good to have the kids standing right out in front of the door. I mean, I'm sorry. Unbelievable. Go ahead, Mr. Trush, I'm sorry.
The only issue that I would raise is within Mr. Laporte's juvenile history, there's a series of things from 2007 that are listed and scored in his juvenile history. I would indicate that he has indicated to me that all of those were delayed adjudications and did not result in actual adjudications. Frankly, with juvenile history, though, I don't know that there's a lot of way for us to actually prove that.
Okay. Mr. DeLeo? Or Mr. Frola?
Well, Judge, I can't speak to what Mr. Laporte may or may not know, but at least as to number 3 of 9, it indicates he was put on probation, and as also indicated number 4 of 9, 5 of 9. So it's a situation where if he was on probation, and apparently 7 of 9, it may be that when he turned 19, then as the courts know, as a matter of law, sometimes those are set aside. Maybe that's what he's thinking. I don't know. But again, quite frankly, Judge, as far as scoring on the probationers, they're misdemeanors, and anything more than 6 doesn't change anything.
All right, well, here's the way I view this. I view, it's the party who's challenging on the accuracy of the report to come forth with information to show that what's in the report isn't correct. I don't think I'm seeing anything that meets that standard at this point, so the court is going to have the report remain as is with regard to adjudications.
Understood. And again, I just wanted to raise it to create the record in case it does become an appeal issue at some point.
Sure. Okay. Any other corrections?
No.
Are there any challenges to the scoring?
Other than, again, what the implication of those potential juvenile things could be now.
Okay. Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor, thank you.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people? Oh, do you have any victims that wish to address the court today?
We do not, Judge. Thank you.
Anything on behalf of the people?
Yes, sir, thank you. These are defendants' 3rd through 9th felonies. They were committed while he was on circumstantial. All of these offenses arose out of the defendant and his wife was matter charges pending, possessing, quite frankly, enough weapons, 35 firearms, including rifles, shotguns, pistols, and short barrel rifles, thousands and thousands of rounds of ammunition, and 17 different calibers, as well as body armor. There were apparently what were converted into anti-personnel place mortars and other assorted weapons, including crossbows, knives, etc., enough to effectively outfit probably what you could say is at least a platoon. In any case, it's a situation not only that he's not supposed to have it because he's a convicted felon, but it's also a situation what was chosen to allegedly and no, now no longer allegedly, was at least one of these weapons was used for, because that's where the damage occurred. And that's how Mr. Laporte was found to be responsible for all of these items. We would ask that in addition to the recommendations that are done, specifically pursuant to MCL 750-239, all the weapons, ammo, parts of the weapons and tools, as well as the body armor and the other explosives, etc., all be confiscated and condemned as required by statute. And as to the restitution amount, as to the malicious destruction of building, that should be $2,603.43, as our victims' rights advocate advises. There was an additional $1,000 that apparently didn't qualify. There's a guideline here of 10 to 28 months, 7.5 months, 7.5 years with 14 days credit. Quite frankly, Judge, if there's a situation where the court wants to consider danger to the community, this speaks volumes that should be agreed.
Thank you, Mr. Church.
Thank you, Your Honor. This is probably one of the most troubling cases that I have had on my dockets. And I say that from two different perspectives. One, as the prosecutor pointed out, there is a lot of firearms present here. And that's hard to wrap your mind around. Why would somebody ever need this amount of firearms? The other thing that makes this case, to me, so troubling is just the level of prevention. The opportunities for this to not have occurred are truly heroic here. And the court's probably a little familiar with what I'm about to discuss from the pretrial motions and sort of things that happened as we approached the trial date here. There's a lot of mitigating factors here in Mr. Laporte's favor, not the least of which is we have a situation here that is abnormal within sort of our system. So Mr. Laporte is convicted of 2 felony drunk drivings. Both of those convictions happened in the district court because at the time he tendered those pleas, he was going into the drug court program. And he'll admit to the court, as he's admitted to me, that at the time he tendered those pleas and was going into that, he was an alcoholic and he was still, in the thralls of his alcoholism. Probably didn't have the clearest understanding of everything that was happening at that time. But the fact remains, for Mr. Laporte, he has this bizarre situation where he pleads to a felony, but is placed on he pleads in the district court, is placed on probation in the district court, and is reporting to the district court. It's a truly unique situation. This is compounded because Mr. Laporte and his wife were looking at potentially adopting a child. Mr. Laporte knows that as part of that process, he's gonna have a background check. So he takes it upon himself preemptively to run a background check on himself because he knows that this is going to happen when he goes to have, when he goes through the process of adopting a child. Much to his surprise, he runs this background check through the Michigan State Police, and it indicates that he is convicted of OWI seconds. This is important because I think this is the first point where things can go different here. And frankly, I think for Mr. Laporte, he takes probably the very steps that I would advise him to take in this place, right? If he came to my office and told me what he was going through and asked me what to do, he took steps that would be pretty consistent with what I would advise him to do. He goes to the next drug court meeting and he begins to talk to the people who should have this information, should be in a position to tell him he's wrong. He talks to his drug court probation officer. He talks to his circuit court probation officer. He's talking with Judge Cooper, who accepted his plea. And frankly, he's talking with Mr. Fenton, who was the prosecutor who handled this. I mean, he shows them his background check that shows that he's not a felon. And I raise all this because each and every one of those people would be in a position to tell him he's not right. Each and every one of those people should know. And I understand that each and every one of those people has lots and lots of cases on their docket. But again, this is an opportunity for this to go a different way. This isn't even where things really go off the rails. Fast forward about 6 months down the road from that, and this is where things go off the rails. Mr. Laporte makes the connection that if he's not a felon, he can purchase firearms. And he does such. And here's where things really go off the rails. Because his background check is wrong, he can purchase firearms. They run a background check on him, and it does not show he's a felon. So he purchases firearms. Again, I can't wrap my mind around the number of firearms that he purchased, but I do think it's important to understand if one is okay, 100 is okay, right? I mean, if he is legally able to purchase one, he's legally able to purchase as many as he wants. So this is where things go off the rails. He relies on this information, and this information that's bad compounds as we go through, right? Each step of the way, this information continues to compound, and it continues to reinforce in his mind this bad information, right? As he gets this, and as he talks to the people involved and no one corrects him, that reinforces in his mind that it's correct. When he goes and is able to pass the background checks, it reinforces in his mind that he's correct. When he runs a subsequent background check on himself and it still shows the same thing, it reinforces in his mind that he's correct, that he's legally able to do this. I can't overstate how much I think that is important for the court to consider. And I say that because accountability is important. We tell people who come in here every single day that they need to be accountable for their actions. They need to be accountable for what they do. And I had that conversation with Mr. Laporte, and he came in here and he made admissions to the court, and he took accountability for his actions. But he asked me a question that I don't have an answer to. Who's taking accountability for it being messed up in the first place? Somebody messed his background check up. And the crazy thing to me is, to this day, I don't believe it's been corrected. To this day, his background check, if you run his state police background check, still does not show those felony convictions. So we're asking him to come in here, and we're asking him to take accountability for his actions. But the government provided him with flawed information, and there's no accountability there. There's no accountability for that. And that just doesn't sit right with me. But the question becomes for the court. The court here has guidelines of 10 to 28 months, which really vests the court with a great deal of discretion. So what should the court do here? There's certainly an element of this that requires punishment. No question there. I would suggest to the court, though, that there's a lot of punishment that's occurred here outside of the traditional way that we think of punishment, right? Through the court system, we think of punishment as fines and jail and prison and probation. And those are the tools in our belt. But quite frankly, what Mr. Laporte has gone through during the process here has been more punishment than the court could ever impose on him. By statute, the court has to forfeit all of the firearms that were involved. The estimated value of those firearms, conservatively, over $60,000. Mr. Laporte is losing his home. His bond conditions prohibited him from being there for significant portions of time, prohibited him from having contact with his wife. His marriage is hanging on by a thread. In spite of this, Mr. Laporte was given an opportunity to maintain his position in the drug court, went on to complete it while this case was still working its way through. He's maintained his sobriety, which if the court looks at his prior history is no small feat. The vast majority of his prior history, at least as an adult, is alcohol related. I would suggest to the court, given the circumstances here, that the punishment that's appropriate is likely a county jail sentence, not a prison sentence. The circumstances just don't warrant it, given the mitigation and the level of punishment that Mr. Laporte has faced, sort of as the natural progression of this. I would suggest to the court and would ask the court to consider, if the court does impose a county jail sentence, to allow him eligibility with the work camp. He's got good support from the work camp, as the court has seen from the letters that we provided to the court. But also just fundamentally the financial situation that this has put him in. If there's a possibility that he can save his house and his marriage, I would ask the court to leave those avenues open to him to be able to do that. Thank you.
Thank you. Mr. Laporte, anything you wanted to say?
Yes, Your Honor. A lot of what Mr. Truce here is saying is true. And, you know, at the time of my sentencing on these original drug drivings, I didn't really quite remember any of what happened. And I'm not saying that that justifies anything. I'm not. I'll take accountability for my actions, but I've already lost so much because of this that I've been fighting for the past year. I've almost lost my sobriety a few times. I've almost lost my mental stability. I'm losing my wife, my kids. I just want the court to know that this isn't what I was. I didn't intend any of this. I mean, look at the pictures of the guns. Truce, what Rolla said is right. I had all that stuff. But if I'm a convicted felon and I knew that, why would I have all that? Does it make any sense? Do I look like that kind of person? I'm not that kind of person. I was in the Chamber of Commerce with my business. I was trying to do good things in this community. This ain't what I wanted. I just wanted to stay sober and have a good life. That was.
Right, thank you. I did read through the report, so I'm obviously familiar with the circumstances surrounding the offenses in this case. We did have a fair amount of proceedings prior to the entry of the plea in this case. So I have more information about the underlying facts here than I normally do in a lot of cases. And this is a difficult case to kind of parse out what really happened here and what is an appropriate way to deal with it, because while Mr. Truce is correct that you can legally buy one gun, you can legally buy 100, but why? It gives me pause when you see somebody with that amount of weapons, ammunition, body armor, and everything else. I'm sure you got explanations for it. I'm sure you have rational reasons for having that kind of arsenal in your home. But I'm telling you, just a normal person on the street looks at that and it doesn't look right. And I don't know what kind of person you are, and looking at you, I have no idea what that means or what it doesn't. But I can tell you that I think just any normal objective reason, the person's going to look at that amount of weapons and ammunition as being unusual and wondering, why does somebody need all of that? That's kind of neither here nor there, other than it makes me look at the whole situation from the standpoint of, what other motivations you had for engaging in some of the activities that you did. The other issue that we have here is, the underlying charges and the questions about that. And I guess I take issue a little bit with, the idea that somehow this is all the fault of some clerk somewhere that entered this improperly. That somehow, the prosecutor or the probation officers or the drug court program has some kind of obligation to properly advise you about whether or not you can buy weapons. I think it's a little bit frightening that the system kind of let all of us down, in that you were able to purchase this number of weapons, having a felony on your record. So I don't disagree with that part of it. I think that's, there are holes there obviously that need to be filled. But ultimately, you pled guilty to those charges, the underlying charges. You should either knew or should have known that you had a felony, regardless of what the records say or anything else. And I think if you're really honest with yourself, I think you probably did know that. And you thought, well, background check doesn't say this, I'm going to go try to purchase a gun. And when that's not a problem, I'm just going to keep buying them. That's what it looks like to me from the outside looking in. And regardless of what the records show, it's hard for me to believe that you didn't know that you had a felony on your record. That still leads us to some of the mitigating factors here, which is I received a lot of letters of support on your behalf from the drug court program, which I put a lot of stock into, from all kinds of other individuals. And so I think there, regardless of your underlying actions or motivations, there are certainly a lot of positives through those letters that give me an indication regarding your character that kind of competes with those negative things. And so it's up to the court to try to balance all of those factors and come up with an appropriate sentence. And in this case, despite my concerns over the number of types of weapons that you had, I don't think a prison sentence is appropriate here when the court looks at this situation as a whole, including mitigating factors. So the court finds that an appropriate sentence is a community sanction of 12 months in the Otsego County Jail. And that's as to all charges. You do have credit for 14 days served. Court does not have an objection to you participating in the work camp program after the first 6 months. You are going to be ordered to pay a crime victims assessment in the amount of $130, for a cost of $325, attorney fees of $350, and a $408 state cost. And that's again for all the weapons charges. For the malicious destruction charge, the court orders that serve. Six months in the Otsego County Jail. You do have credit for 14 days served. Court is going to order restitution in the amount of $3,603.43 payable to the Otsego County Clerk to be dispersed to Northern Energy, and a $50 state cost. You do have the ability to seek an appeal of this sentence. You should let me know once the court has acknowledged receipt.
Judge,
Yes.
I believe the restitution was actually $2,603.43. This is $1,000, and I understand it did not qualify for restitution purposes.
Okay.
With the court's permission, I have another comment I'd like to make for the record as an officer of the court.
Sure.
Thank you, Robert. Two things, one of which is the court's orders pursuant to MCL 750-239, all the weapons as compensation to them. The other thing I want to verify is that there's comments made on this record by numerous parties that the defendant's criminal history did not show his prior criminal conviction. That's an inaccurate statement. What it didn't show was on his iChat. So that's his Michigan record. But on iChat, it also indicates at the very bottom of the form that's not to be relied upon as the basis for a criminal history, because the defendant CCH clearly indicated his prior felony convictions. And I think to state to the contrary is not only factually false, but wrong as a matter of law.
Okay.
Yeah, I don't want to go too far down the rabbit hole, but I think it's entirely disingenuous to suggest that the Michigan State Police maintain the sole database of criminal history in the state of Michigan, but can just say, don't rely on our information. that's ridiculous.
Well, I don't think that's what it says. I think what it says is you have to go to the actual criminal history record, and you can't rely on what's online. And whether that's reasonable or not, that's their policy. And again, I really don't think any of that matters, because I think Mr. Laporte has an obligation to know what he's convicted of and what he's not convicted of. And he was, I'm sure, advised that at the time he entered his plea in the underlying cases and was sentenced. And I'm sure if he looked at his judgment sentence in that case, it would indicate that. So there's plenty of records that indicate the conviction. Yes, sir.
And I'm returning the notice of appellate rights to the court.
Mr. Hallman here yet?
I've not seen him come in, but I think Mr. Kukowski has a case that might be open.
All right, Mr. Kwiatkowski, were you ready with your case?
I am, Your Honor. The people, or the court will call Mr. Rushlow.
Yes, People versus Rochelo, case number 246708.
Record, Your Honor, myself, I have people.
And Luke Kuski on behalf of Mr. Rolla,
No, you're not.
Rushlow.
All right, thank you. This is set for a status conference in this case today. Mr. Kwiatkowski, can you tell me where things stand from the defense standpoint?
Yes, Your Honor, be happy to. I did just receive from the prosecutor's office a other acts notice that I would like some time to respond to. Additionally, this was a case that involved a forensic dump of a cell phone and some other electronic devices, in which I just got partial download of those dumps. I did send a zip drive or a hard drive to the state police and received that back in the mail this last week. And so I do have that evidence now to vet through and go through. Actually looking at getting an expert to maybe help me go through those things. So I kind of asked the court for maybe another month in order to hash those things out and see where we're at that time. I don't want to clog up the court's trial docket or anything like that any further.
Are you anticipating this going to trial? I mean, I understand there's a lot to work out before you get to that point.
At this time, Your Honor, looking at the offer, looking at Explorer, he is, it looks like 0 to 9 potentially on that offer. I know it's got a case in Sheboygan that kind of going at the same pace here. I do see it resolving. I don't see it going to a trial.
Mr. Rolla, do you have any objection to the adjournment that's being requested?
No, Your Honor, and I would confirm, as defense counsel indicated on the record, we did file a notice of other bad acts required to prior to the status conference. Where this is going to be the final one, and that didn't matter. In any case, I also am aware that there are discussions going on right now to resolve this case along with the defendant's matters in Sheboygan. And so the defendant can go over the rest of the new discovery materials he's just recently received. We have absolutely no objection.
All right, what I'd like to do is just build in a little extra time. Mr. Kwiatkowski, I heard you mentioned you may want to have somebody review those records. So I'd like to set this for a plea hearing status conference in 60 days. I think it'd be a little more prudent to do that, given the status right now, as opposed to coming back in 30 days and having to wait for 30. So
I think that makes sense, Your Honor.
yeah, so I guess Mr. Rochelo, just make sure that you stay in touch with Mr. Kwiatkowski. And then at that next hearing in about 60 days, I'm going to be asking you for a final decision about whether you want to enter into plea offers, okay?
Okay.
So that'll be a big date for you to make sure that you're ready and that you've talked about all your options with Mr. Kwiatkowski and that you're ready to make a decision. Okay?
Yes, sir.
All right. Mr. Roll, anything further that we can address?
Thank you.
Nothing further to defense, Your Honor. Thank you.
All right, our next case is People versus Ingersoll. Mr. Hallman, who's one of the attorneys on that case, had called the court this morning, indicated that he was having car trouble, that he would be here between 10:30 and 10:45. So we may take a short break. Counsel, are you appearing on the GAN matter?
Yes, I am.
Okay, we're going to get Ms. Gann here available here in a second. So I'm just going to put you back in the waiting room for just a few minutes and then we'll get started, okay?
Very good. Thank you, Your Honor.
Okay, thanks. All right, so we can get Ms. Gann and polycom, and we'll take a short recess. We'll come back on the record in about 5 minutes.
All rise.
Ms. Khan, are you able to hear me okay?
Yes.
Okay, we're just waiting for your attorney to sign in and then we'll get started with your case, all right?
Okay.
Okay, we're on the record now in People versus Nigel Ingersoll. This is case number 2366572466704 and 705. If I could have all counsel put your names down.
Your Honor, Richard Trush on behalf of Mr. Ingersoll.
On behalf of Mr. Ingersoll as well, Your Honor, Zachary Holmes.
And I am Mr. Ingersoll.
Thank you. This is the date and time set for sentencing in this matter. Mr. Ingersoll, have you had a chance to go through the pre-sentence report and talk to your attorneys about that?
Yes, Your Honor, I have.
Mr. Hallman, dealing with your files first, are there any additions, corrections, or deletions to the report?
No, I don't believe so, Your Honor. I'll defer to
Do
you.
you have any additions, deletions, or corrections to the report?
I do have a few. So the first one would be on CFJ 101, page 1. And this is the basic information report. I don't know if the court will actually make this correction. Mr. Ingersoll indicates they have an alias listed for him with his last name spelled differently. He indicates he's never used that name, that's not an alias for him. Again, I don't know if the court's actually inclined to make that correction, but it looks like it's just his last name that's misspelled there.
Judge, that's the name that comes from the defendant CCH, where they have one and they use fingerprint glass, etc. So again, I believe that's where it got into. I'm not saying Mr. Ingersoll ever used it because I don't know personally. All I'm saying is it's my understanding that's where they got it.
All right, I don't think it's not gonna affect sentencing in any way. And that's where that's what the data is, unless I have something positive to show that that's incorrect. I'm not gonna pass this.
That's not unexpected. The second is on CFJ 145, that's page 2. And this is under the section titled Department of Corrections Recommendation. Specifically in regards to file 23-6657FH, count 2. It lists that the domestic violence be sentenced to 6 months incarceration in the county jail. I think that's just a typo. The domestic violence is a 93-day misdemeanor.
Any objection to correcting that, Mr. Rowland?
No.
Then jumping ahead to CFJ 284, page 12. This is the adult criminal history entry number 16 of 19.
Okay.
They have listed the final charges on there are count 1, importing and manufacturing a firearm. I think that's inaccurate. Count 1, as we show it, reflects the same as what charge count 1 is, which would be making a false statement to purchase a firearm. And Mr. Hallman may be able to speak more directly to that.
Well, that's exactly accurate. I represented Mr. Ingersoll for that charge, and there was no manufacturing charge as far as we remember even charged.
Sorry, Mr. Rowland.
Well, Judge, it would have been easy to correct, especially if we brought a copy of his judgment of sentence back to the court. I have no idea what that is. Take Mr. Holman at his word.
All right, based on Mr. Hallman's representations here today as an officer of the court, let's have that and word that corrected to reflect at 16 of 19 that the charge at arrest was also the final charge. Any other corrections?
Yes, last one, Your Honor. This is on CFJ 284, page 14. And this is under the section gang marks, scars, and/or tattoos. It lists that he has a back tattoo of a 7 with a crown on it. I think that's likely just a carryover from another PSI. Mr. Ingersoll indicates that that's been covered by another tattoo, specifically a skull with a beanie on it.
All right, Mr. Roll, any objection to that change? Okay. Okay. Any other changes?
No, Your Honor.
All right, counsel, either of you have any challenges to the scoring of the guidelines?
No, Your Honor.
Defense counsel, sorry.
Right, no, Your Honor.
Thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections.
People have any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
We do, Judge.
Counsel, if you and Mr. Ingersoll can be seated at council table there, and if you come right at the podium, please. And can you tell me your first and last name?
My first name is Cassandra, last name Ingersoll.
And what is it that you would like to say here today?
I just want to say that Nigel and I have been in pretty regular contact since all of this has happened. I'm sorry that we have to be here for it. Thank you for your time. But I believe that he is extremely remorseful for the decisions that he made on that night in September. And he has small children, and I just want you to take in consideration that he deserves to be a father to them before it's too late. He can be a really good guy. He does have great qualities. He just makes bad decisions sometimes, like we all do. And I think that the recommendation is good. I don't ask for any harsh punishments or anything like that. Time served, like I think that he's doing well in there. And, helping himself, bettering himself, and taking steps in the right direction. And I think that he just deserves to have a chance to live a better life. And I also ask that upon his release, that he was not required to come back to Gaylord, Michigan. I think for him to be as far away from here as possible is the best thing for him. I don't think him coming back and being forced to be on probation around all of the people and things that have caused him problems for years now, I don't think that that's a good choice for him. So I would just ask that he wasn't required to come back to Gaylord, Michigan, just because I don't think that it's good for him. And that's what I have to say.
All right, thank you. Appreciate that. Mr. Rolo.
No, Your Honor.
Counsel, if you and Mr. Ingersoll want to return to the podium, Mr. Rolo, anything on behalf of the people for allocution today?
Yes, Judge, in regards to cases 23-665-7, that's the domestic violence that's in this community, as well as the case 24-6705, using the computer to commit an offense, also missing the recommendations that were appropriate. The greater concern is actually file number 24-6704. The felonious assault. This is the 6th felony committed while the defendant was on probation. And while I somewhat sympathize, or at least maybe understand situations with the victims in this case, the people do in fact have concerns that the defendant was apparently now it's been confirmed having communications with the victims while these matters were proceeding, whether for whatever reason that is, I don't know. And the people are aware that we may have been looking at other charges as well, including witness victim intimidation. We think that a recommendation of jail from some time served for a 6th felony is appropriate. And as far as the defendant being allowed to leave the state of Michigan because that may cause him to come in contact with other people, well, again, Judge, I don't think he should be able to leave until his sentence in Michigan and the probation term should be completed. So that way, at least this court can keep some, if you will, observations and control over Mr. Ingersoll's behavior, which he clearly can't do on his own.
All right, thank you. Counsel, I'm not sure if either or both of you want to make statements on behalf of Mr. Ingersoll today.
Go ahead.
Thank you. I mean, first, Your Honor, just to make a clear record, I mean, we know what the content of the communications between Nigel and his wife were. They were recorded. He was charged with witness intimidation, although it was ultimately dismissed as part of the plea to the obstruction. I mean, there's no secret there. Not going to make any excuses for Nigel's conduct here. There is no excuse for it. He knows better than this. But there are two sides to this coin. We're not our worst moments any more than we are our best moments. Nigel, you can see from his history, has some times when he makes some pretty boneheaded decisions and does some, frankly, just dumb things. He doesn't make good decisions. No question about that. But I think it's also important to understand there's a whole nother side to Nigel, a side of Nigel that displays the qualities we want to encourage in our community. So I want to highlight for the court some of the other things that Nigel does. Nigel's involved in a local business here, or was until his incarceration. Through that business, he participated in a lot of things within our community that he should be applauded for and displayed qualities I think are good. He's participated in handing out candy on Main Street on Halloween. He's donated to victims of the tornado. He's participated through the business in Toys for Tots. In fact, when they did this, they filled up their bin and had to go get a second box because they had such a good turnout and were able to fill it so quickly. He's donated to local school events, athletic teams, and food drives. And he's donated his time as an artist to doing tattoos on veterans for free. I highlight these things to the court because, as I said before, we're not the worst decisions we make and we're not the best decisions we make. I've talked to Nigel and I know that it tears him up to be away from his kids and away from his family. And I've talked to him about his family and his kids. And I know that the qualities that I've highlighted here are the things that he wants to model and display for his kids. He knows that he doesn't want to model the behaviors that happened on that night. I think that the recommendations here are appropriate given the circumstances. As the court may not be aware or likely to become aware, he has been sentenced in the federal matter. I believe 26 months is the sentence that was handed down. The recommendation here for a year to run concurrent with that would make sense. I think structurally it makes a lot of sense. So I would ask the court to follow that.
Thank you. Mr. Ingersoll, anything that you wanted to say today?
I do, Aaron, I know that when you ask if I have anything to say, I know what you're really asking me is if I have any regret or if I hold any remorse for what happened the night this all went down. The answer is, I hope a parent, concluding my statement, truthfully, I'm embarrassed by what happened. I'm disappointed in myself because I knew better. You know, I'm not a menace to this community, but rather I was a pillar. I had eyes on me everywhere. There's a lot of people that looked up to me, and I let a lot of people down. And for that, I'd like to publicly apologize. You know, there's many moments in my life that I'm more than proud to have been a part of. And then there's moments that I'm not so proud of. This obviously being one of them. I dropped the ball and I let some folks down. You know, I have apologized to Cassandra and I've made amends with her to the best of my abilities. You know, I promised to come out of this a better man, no matter what the outcome is. And I know that with some effort, I can and I will. With my federal sentence, there's more time to come. But for the last 267 days, I've had more than enough time to reflect on my entire life and reevaluate, reprioritize the things in my life that are the most important. I know that I owe it to myself, this great nation, and my children to be somebody they can not only look up to, but rely on as well. As expected, you know, the time that I've been away from my children has been devastating. And hearing them tell me that they miss me over the phone, you know, my 2-year-old daughter asked me where I'm at, and I don't have the heart to tell her that I'm in jail. It hits different. And, it's been devastating. And it breaks my heart. And even worse, it breaks their heart. So with that, I'm going to ask for the opportunity to return to them in a timely manner by adopting the full recommendation set forth by the Corrections Department. I believe that I've acknowledged my guilt. I hope that I answered your question, and I've taken accountability for my actions. So with all that being said, Your Honor, I'm ready to face the consequences.
Okay, thank you. I did review the report, so I'm familiar with the circumstances involving each of these files that bring before the court here today. I also reviewed the background information in the report, so I have an understanding of your own personal situation and your circumstances as well. Looking at the report as a whole and taking into account the other, penalties for the federal charges that you're going to be facing. Number one, I agree that probation is not appropriate here. I think a straight jail sentence for each of these charges will accomplish the goals of the court, which is to punish you, provide a degree of punishment for your conduct in this case. Hopefully provide a deterrent going forward as well. And I do think that the recommendation as prepared is appropriate. I think it adequately accounts for your conduct in this case and your circumstances as a whole. So the court is going to follow that recommendation. As to file number 236657, count 2, domestic violence, 93 days in the Otsego County Jail with credit for 1 day served. Crime victims assessment of $75 and a $50 state cost. Count 3, felonious assault, 12 months in the Otsego County Jail with credit for 1 day served and a $50 state cost. The sentence in that file to be served concurrent with the other sentences here today, as well as your federal sentence. File number 246704, count 1, obstruction of justice, 12 months in the Otsego County Jail with credit for 0 days served, crime victims assessment of $130, court costs of $325, attorney fees of $350, and the state cost of $68. Again, that file to be served concurrent with other files and your federal sentence. And then finally, file number 246705, using a computer to commit a crime, 6 months in the Otsego County Jail, credit for 0 days served, and a crime victim's assessment of $130, and a state cost of $68. The court's not going to impose any additional court costs or attorney fees on that file. Again, that file will be served concurrent with the others and your federal sentence. You have the ability to seek an appeal of each of these sentences, and we do need to give you your appellate rights today, though. So Mr. Trush or Mr. Holman, you can let me know.
Will not be appealing that. I want to say thank you for not throwing a curveball at me.
I'm returning the notice of appellate rights back to the court.
Okay, thank you. Mr. Emerselli, you are into the custody of the county at this time. Good luck going forward.
Thank you very much.
Okay, Mr. Brown, are you able to hear me all right?
Yes, I am, Judge.
And Ms. Gahn present, and then got the PG's office connected in as well. All right, we're on the record now in People versus Rachel Gahn. This is case number 236641. The record should reflect the defendant is present today by video from Otsego County Jail. If I could have counsel put your appearances on, please.
Good morning, Your Honor. Robert Mirkay, Special Assistant to the Attorney General on behalf of the people.
Larry Brown on behalf of Ms. Gahn.
Thank you. This is set for a status conference in this case today. Mr. Brown, can you tell me where things are at from the defense side?
Yes, Your Honor. As the court is aware, we had a status conference a couple of weeks ago in which Ms. Gahn indicated there potential money that should have been applied to child support. Given the arrearages, there was no way she was going to be able to take advantage of that offer, the tiered offer. There was another offer made to plead to count 1 and dismiss count 2. I believe we are going to take advantage of that today. And for the record, what Ms. Gahn was talking about was back in 2020. She apparently is telling me she had the children the majority of the year, but her husband claimed them and he got all of the tax money, and she filed something with the IRS to try to correct that. But that has been 4 years ago. It's never been corrected. And the fact is, it was a valid order for support at that time. So given that background, Your Honor, I believe she is willing to take advantage of the offer to plead to 1 count.
All right, Ms. Gahn, is that how you wanted to proceed today?
Yes.
And Mr. Mirkay, is that a correct statement of the offer?
It is, Your Honor.
Okay. Ms. Gahn, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Ms. Gahn, are you apparently on any kind of probation or parole?
No.
You understand that by pleading guilty to count 2, which is failing to pay child support, that's a felony that carries with it a maximum possible penalty of up to 4 years and or a $2,000 fine?
I do.
With that in mind, what is your plea to that charge today?
I'm sorry, can you repeat that?
Yes, what is your plea to that charge today?
I'm guilty of not paying.
Okay, I'm gonna go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand that you have all of those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty today?
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes.
And are you pleading guilty because you are guilty?
Yes.
All right, so between October of 2021 and May of 2022, is there an order from Otsego County here for you to pay child support?
going on, man. I can't hear them.
I'm sorry. I couldn't hear what you said. I'm sorry.
Yeah, hold on.
Sorry about that.
Okay. Ms. Gahn, between October of 2021 and May of 2022, were you subject to an order here in Otsego County that required you to pay child support?
Yes.
Okay, and did you fail to pay support either in the amounts required or at the times required?
Yes, I failed to pay.
Okay. All right, Mr. Murkey, do you have any further questions in terms of the factual basis?
No, Your Honor, thank you.
Mr. Brown?
No, Your Honor, I believe there's an adequate factual basis.
Thank you. Mr. Murkey, are the people aware of any threats, promises, or inducements other than what's been placed on the record today?
No, Your Honor.
Mr. Brown?
Your Honor, I am not aware, and I also believe the court has complied with statute and court rule for taking pleas.
Mr. Murkey, are the people satisfied the court has complied with statute and court rule?
I believe.
Thank you. Ms. Gahn, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. We'll set this matter for a sentencing hearing. Prior to that date, somebody from the probation department will be in touch with you to prepare a pre-sentence report. Mr. Brown, anything further we need to address here today from your side?
No, Your Honor, thank you.
Mr. Murkey?
Your Honor, I'm sorry.
Yeah, go ahead.
Is there a way to get out on bond so I can get to work?
Mr. Brown, your attorney would have to make a motion for the court to reinstate bond.
Okay.
So you'll need to talk to him about that.
Okay, thank you, Your Honor.
Okay, thank you. That's all for this hearing today. And the court is going to go ahead and disconnect from the jail, and all parties are free to disconnect at this time. All right, Mr. Dundon, if you can unmute, please.
Yes, sir.
Go on the record in German versus German. This is case number 2419580. The record should reflect that Mr. Dundon is here on behalf of Ms. German, who's also present, both of those parties by Zoom video. This hearing was set for 11 o'clock. It's now 11:15. I don't see anybody on behalf of Mr. German appearing for Mr. German himself. Mr. Dundon, I am in receipt of a proposed judgment of divorce. And is that how you wanted to proceed today?
Yes, Your Honor. I'm kind of surprised, Mr. German. I spoke with him this weekend. I've talked to him quite a bit in the last week. So he, as an officer of the court, I can definitely certify he signed the judgment, was very much a part of how, the terms went back and forth, Your Honor. But
Okay,
yes, if you could do the, sorry, Judge.
Nope, that's all right. I do see that it does appear that he signed the proposed judgment. And again, we're 15 minutes past time. And so it looks like he's elected not to appear today, but we can move forward. Ms. German, can you unmute, please? Thank you.
Good morning.
Morning, ma'am. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand, and Mr. Dundon, please proceed.
Thank you. Could you please state your name for the record?
Stacy Lynn German.
And you're currently married to Ricardo Anthony German?
Yes.
When did you guys get married?
January 1st, 2022.
Okay, and that was by a person authorized to perform marriages?
Yes.
Okay, and you came to my office to file a complaint for divorce, correct?
Yes.
And at that time, had you been living in the state of Michigan for 180 days?
Yes.
Had you been living in Otsego County for 10 days?
Yes.
And would you say that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and that there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Okay, are you currently pregnant?
No.
Okay, and you and I negotiated a consent judgment of divorce, correct?
Yes.
And do you find those terms to be fair and equitable as far as property division?
Yes.
And you understand by signing this that you were agreeing to never receive spousal support, and you can never go back and ask the court to reopen that issue. Is that correct?
Correct.
Okay. And again, you were asking the court to sign and enter the consent judgment of divorce that you and I put together and you signed?
Yes.
Okay. Your Honor, thank you. I don't believe I have any other questions.
All right, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. German. The court will grant the divorce. I've reviewed the judgment and find that it's equitable and contains all the provisions required by law. So I'll sign that judgment here today. Mr. Dundon, is there anything else that we need to address on this case today?
No, thank you, Your Honor.
Okay, thank you. All parties on this file are free to disconnect at this time.
Thank you, Judge.
Thank you.
All right, Ms. Hoffman, are you appearing on the Platinum Country Rentals versus Orion Lick case?
Yes, I am, Your Honor.
Okay, we're on the record in that file. That is file number 2319197. We have Ms. Hoffman here on behalf of plaintiff. This is set for a hearing today on the plaintiff's motion to appoint a successor court officer. I did have a chance to review that motion prior to the hearing today. I have to admit that I have not had this kind of motion brought before me. So can you tell me a little bit about what you're asking for and why, in addition to what is in the written motion?
Just really to accentuate the fact that we have a $43,000 plus judgment against the defendant. We were able to determine that he has two assets of a 2012 Ram truck and a 2003 Lincoln Aviator. And to our knowledge, they are at his place of residence. And then when we filed the execution, Mr. Reed was appointed as a court officer, and we've tried to contact him at least 3 times for a status update, and we've received no communication from him. So we just wanted to get another court officer that might make some effort to go out there and pick up those assets, or at least go out there, and if they can't pick them up, at least let us know what is going on.
Okay. All right. So I had a chance again, as I said, to review the file here today. I do note that this motion was properly served both on the defendant and Mr. Reed. Neither party, and again, this hearing was set for 11:15. It's now 11:22. No one else has appeared either virtually or in person to contest the relief requested. So the court will grant the relief. And Ms. Hoffman, I was just looking to see if there was an order submitted with the motion. I didn't see one. So did you want to submit that?
I will submit that, Your Honor, and I'm assuming that it would just be a different officer within the Otsego County Sheriff's Department. And unless you have an idea of maybe an outside company. It's kind
That
of a
would
new.
really be, that would be outside the scope of my typical involvement in these matters, so.
Okay.
I'm gonna give that to you to determine how you want to go forward, and but I'll be happy to sign the order once that's submitted.
Okay, all right. Thank you, and thank you for your time today.
Okay, thank you. You're free to disconnect. that?
Are we supposed to stand? No. Okay, all right. Last one. Thanks.
Good morning, Your Honor.
Hi, good morning.
I was zooming in and it wouldn't connect, so I called the county clerk to get the number and then it came back on. So here I am. And I just talked to Lynn Marie Mullen a few minutes ago, and I believe she's zooming in. She was planning to.
Yep, looks like she's connected. So we'll go on the record now. This is Mullen versus Brzezinski. This is case number 2118497. If I could have counsel put your appearances on.
Yes, Hob Engelson for the plaintiff, Lynn Marie Mullen.
Appearing on behalf and with my clients, the defendants in this matter.
Okay, the court set this for a status conference today. I think what we're all trying to do here, and I'm sure counsel will correct me if I'm wrong, is get this case closed. So I don't know, Mr. Engelson, do you want to start on behalf of plaintiff, and where are things at right now, and what do we need to do to get this resolved?
Yes, as the court perhaps knows, Mr. Carey and I met with our clients, and Jack Turner, a mediator, reached a written agreement almost 2 years ago. And then we went back and forth about, first of all, we got a survey, and Brian Fulford from Indian River did it. And then we had difficulty connecting on getting the deeds executed. More recently, Mr. Fulford came out again because it appears that, right or wrong, but it appears as if the east-west line of the settlement angles to the north, which would change the dimensions of the settlement territory, because this was a adverse possession matter involving a 15-foot strip along the boundary line between the parties. Mr. Fulford, I spoke to him recently on a couple of occasions, and he's talked to my client, and my client and her husband, who is a engineer at GM Proving Grounds, are going to be here July 15 to August 2nd. Mr. Fulford has agreed to come back out again, and I'm going to participate just because I want to see it on the ground with him there to verify that the survey lines, of course, match the settlement lines, or they don't, so that we can execute the deed, dismiss the case, or if there's some redrawing of the line that has to occur, then I certainly would want to have Mr. Fulford pointed out to Mr. Carey and myself. And so I'm sorry it's 2 years later, Your Honor. We're prepared to resolve it, and we have been all this long time, but this question has arisen, and I would like the forbearance of the court through the month of July to, I don't think an exact date has yet been set. My clients are going to be there, as I said, from the 15th to the 2nd. Mr. Fulford said he will come over. So if we could do that and either satisfy we're all on the same page as we're supposed to be, submit the dismissal, that'll be the end of it. Or if there's a question about it, certainly Mr. Carey and I can notify the court and let you know what we need to do to get it rectified. There isn't any goal to not complete this. It's just been a difficult to reconcile what appears to have been, what appears on the ground versus the agreement / the survey. So That's my position and request.
Okay, thank you. Mr. Carey?
First I've heard of all of this. Don't know how long the question has been hanging around as to a potential discrepancy between the survey and the settlement agreement. What I do know is that we have tendered a deed in accord with the settlement agreement. My clients have signed that deed and we have tendered it to the court, almost asking the court to be escrow agent for us. But we wanted to show the court that we have fulfilled the terms of the mediated settlement agreement. I think anybody wants to get anything wrong. But I just wonder if the survey was done in November of 2022 and it was all staked out, and I know it was all staked out because I saw the stakes. How can there be a question about reconciliation of the settlement agreement description and the survey description 18 months later? That's a question I have. And then as a request that I have is if the court is inclined to give the plaintiff additional time to see that the settlement agreement reconciles with the survey, the plaintiff should be paying in her money to the court. Why isn't that paid in?
1 second, can you say that again?
Hopefully just the last part. Why
Yes.
isn't the money paid in?
All right, Mr. Engelson, can you address either of those questions for Mr. Carey?
Well, I don't have any problem getting the money, and I know my clients have it. They've confirmed they have it. It's never been an issue. I'll have them send me the money and I'll have it delivered to Mr. Carey's office, payable however he wants it. As to the second question, I can only relate to you the concern that's been arisen. They're not trying to, it's not any land grab idea. It's just that it's unsettled in my client's mind that the lines comport with the settlement. And I think I'm hopeful and confident that Mr. Fulford coming again and explaining it, again to my client as well as her husband and to myself, that we'll see that what appears is not incorrect. That's all I'm trying to do. There's no goal. There's no goal to not agree to the settlement and complete this matter. There's simply a request. We've gone this long. I don't know how another 30 days to have the surveyor back out is in any way swimming upstream. So.
Okay, well, here's what I'd propose as a way to move things forward. Mr. Carey, I think what would need to have happen here, and what I'm hearing is that your clients want to, want the mediation agreement to be put into effect. So I think the question would be, and what the court would allow is 60 days for the parties to try to reach a resolution. And then Mr. Carey, to the extent that hasn't happened, then I think we would have to have a motion from your side. I would suggest that be set for hearing in August on the court's normal motion call. And if there's a legal basis to go forward, then we'll go forward. But the court would hear arguments for both sides about how to proceed. But I think we would need a motion to the extent that Mr. Carey, that your clients have rights under whatever agreements that have been made and that need to be enforced.
I appreciate the court's comments, and if that's what's necessary, that's what we'll do. I think it's a little bit ironic that 90 days ago, the plaintiff filed a motion for enforcement of settlement agreement.
Do you want us to
But-
spat on the record, Your Honor, or not? Because I could.
Well, this isn't
I don't think
set
it's
for a motion
necessary.
hearing. This isn't set for a motion hearing today. I guess I could say either side, but I would put a deadline for either side to file motions in this case for August. And
All
then
right.
if you guys if it can't get worked out between now and then the court will have to make some decisions based on whatever the parties file. But either way,
That's
that gives
fine.
us a deadline for it either to get resolved or to get before the court for some decisions so that everybody can move forward.
All right, and Matt, was the court, before I moved forward, was the court having difficulty hearing me?
No, it wasn't on your end.
Okay,
So you're fine.
thank you.
Yeah.
Okay, very good. I've just had trouble with a mediation Zoom last Thursday with the mediator hearing me, and I wondered if that was a system problem. But thank you, Judge. Appreciate where the court's coming from. And I'm sorry, I even made my last comment. It was out of line, counsel. I apologize for that.
No problem. Thanks. Thank you, Your Honor. I'll be in
All right, so
touch, Bill.
I'll put what we've discussed today into a status conference order and get that out to the parties.
All right. Thanks
Thank you,
very
Judge.
much. All right.
Okay. Thank you. All parties are free to disconnect. And